Kansas City, and beyond. This is no Engle here. That's right. No John Paul Engle here. The one and only no John Paul Engle. This is Today in Politics. You see, there's no Engle, but there's no John Paul Engle. And this is Today in Politics. Today's topic is moron 18 U.S. Code, tampering, 1512, tampering with a witness, victim, or informant for interfering in my lawsuit against their employer, who, KY3, and Gray Media, that's who. Today is Friday, October 24th, 2025. I asked Mr. Google, is a plaintiff to a lawsuit considered a witness to a lawsuit under 18 U.S. Code 1512, tampering with a witness, victim, or informant? See in federal lawsuit of no John Paul Engle versus KY3 News of Springfield, Missouri, and Gray Media. I'm the plaintiff, and they're the defendants. I filed against KY3 as of May 1st, 2025, with last case number 4/2025 MC 09006, as according to Justia dockets and filings, which is another form of federal court public records, in which lawsuits are public record from the federal court, you see. So, now that I've established myself as a plaintiff in no John Paul Engle versus KY3 News of Springfield, Missouri, and Gray Media, I believe I would qualify as a witness according to what Mr. Google has to say about it. Mr. Google says, yes, plaintiff is considered a witness in a lawsuit and can be subject to of 18 U.S. Code 1512 if someone attempts to tamper with their testimony. The law protects witness, victims, or informants. How about that? From actions intended to influence, delay, prevent their testimony, and plaintiff's testimony is crucial to their own case. Therefore, tampering with a plaintiff in a lawsuit is a violation of this statute. Oh, no shit. Well, for the record, the employees of the defendant in KY3 News of Springfield, Missouri, the Gray Media, have been using electronics, internet provided by Gray Media under 18 U.S. Code 2 Principles. It says, whoever commits an offense against the United States, or aids, or abets, counsels, commands, induces, procures, commissions, is punishable as principal. Whoever willfully causes an act to be done which is directly performed by him or another would be an offense against the United States is punishable as a principal. On the matter of no John Paul Engle versus KY3 News of Springfield, Missouri, and Gray Media, I asked Mr. Google this: can a boss or president of a corporation be charged with 18 U.S. Code 2 Principles for its employees' actions. Mr. Google says, yes, a boss or president of a corporation can be charged as a principal under 18 U.S. Code 2 for the actions of their employees, but not only for simply being their superior. The prosecution must prove the executive's direct involvement in or deliberate ignorance of criminal activity. I need a water break. So, the executives, and I believe they know what now the employees of KY3 and KCD5 had been doing to me and are aware, if not encourage such activity. They could also be charged with tampering. 18 U.S. Code 1512, tampering with a witness, victim, or an informant. Under 18 U.S. Code 2 principles, and I will talk later about 18 U.S. Code 1513, retaliating against a witness, victim, or informant. I do not have time in this video to discuss this law, as it also applies. I had asked good old Mr. Google this: what are the elements of 2 U.S. Code 2 principles? And the core principles of Code 2 are 18 U.S. Code 2 are that anyone who commits a federal offense or aids, abets, counsels, commands, induces, procures, remember that, procures, its commission is punishable as a principle. The elements required to prove aiding, abetting under 2 are specific intent to facilitate the commission of a crime by another. 2. Require the intent of the underlying substantive offense, the theory that the accused assisted or participated in commission of the underlying offense, and that someone committed the underlying offense. Section 2b has similar principle for when willfully causes an act to be done which would be a crime if they did it directly. So, this is how they being the executives of great media, because they had been defendant, also can be charged with 18 U.S. Code 2 principles and 18 U.S. Code 1512, tampering with a witness, victim, or informant. In this law, particular, I believe, because they are using, I'm assuming, gray media provided internet to communicate this crime. To tamper me with is essentially in progress with their comments and their use of technology likely provided for by gray media. Also is how the executives can be charged with 18 U.S. Code 2 principles and 18 U.S. Code tampering with a witness, victim, or informant, and likely 18 U.S. Code 1513, retaliating against a witness, victim, or an informant, among other laws. they could be charged with. I had asked good old Mr. Google this when providing internet to use in a criminal means be a procurer. Yes, knowingly providing internet access to someone so they can commit a crime can be considered a form of procurement. The liability depends on your knowledge and internet intent. So this is how the executives could be charged for employees' actions of the official proceeding a federal lawsuit in federal court before federal district Judge Bo, even though it was dismissed. Now, I could be a witness to other activities of employees of the defendants, you see, because of the impending lawsuit against Judge Bo. With that said, federal crimes, most federal crimes have what are called elements, and that the federal prosecutor or U.S. attorney, for that matter, must, in order to prosecute the case in regards to any criminal case. And I had asked Mr. Google this: what are the elements of 18 U.S. Code 1512, tampering with a witness, victim, or informant? The elements of 18 U.S. Code 1512 require the defendant to knowingly use or attempt to use physical force or threat of physical force against another person with specific intent to obstruct, influence, or impede an official proceeding or law enforcement investigation. This includes actions like preventing testimony or production of evidence, hindering communication with law enforcement, or otherwise corruptly influencing, impeding the proceeding. I had asked Mr. Google this: what is the legal definition of corruptly influencing or impeding a proceeding? And Mr. Google says the legal definition: corruptly influencing, impeding a process involves acting with an evil, wicked, or improper purpose to obstruct or interfere with an official proceeding. Corruptly means the act was done for an unlawful purpose, while it can include making false statements, withholding or destroying evidence, or with otherwise taking action with the intent to subvert the administration of justice. I believe the other reason that employees, and the plaintiff, Mr. Noel, John Paul Engel, myself, versus defendants, KY3 News of Springfield, Missouri, and Gray Media, Atlanta, Georgia, had participated in tampering and retaliation acts against the plaintiff, ongoing acts primarily to punish the plaintiff for his lawsuits, primarily, and that say I don't get nothing or anything as a means to punish me also, and other acts of retaliation and tampering in that, and ongoing. So, that's all I can say about that for now. I'm not doing this for for the money. No, it has more to do with justice, as I'm saying, I want justice, that more so than the money. I want justice against these bastards. So, that's what I'm trying to seek. So, this has been Today in Politics with Noel Paul Engel. Thanks for watching and listening to me rant away. Have a good day.